Dear Professor, thank you for the introduction. Unfortunately, my presentation had failed me, so we had technical difficulties, which I apologize once more. Today I will speak about... Sorry? No, it's fine. Thank you. Today I will speak about the delicate topic that are refugees and immigrants and the challenges they and their host countries face nowadays, with the emphasis on the Croatian experience, of course. I'm well aware that this topic is very broad, therefore I will do my best to present to you the most important parts. So, without further ado, I would like to start my presentation. So, this topic had always been an intriguing and important subject to speak about and to care about. This presentation, unfortunately, comes in delicate, not to say dark times of our existence. So, I have divided the PowerPoint, which you cannot see, unfortunately, in two parts. One that deals with the fundamental issues and the other that deals with Croatian experience. To be able to understand the legal status of these groups, firstly we have to use the right terminology. And here we define certain groups that are, for example, displaced persons, refugees, and asylum seekers. Displaced persons are people who move away from the region or country where they lived against their will, and the cause of this is a direct order or threat from the oppressor. Refugees, defined by the UN Convention relating to the status of refugees from 1951. The Convention defines a refugee as someone who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of their nationality and is unable, or owing to such fear, is unwilling to avail themselves of the protection of that country. Asylum seeker, on the other hand, is a foreigner, for example in the Republic of Croatia, who submits an asylum application on which a final decision has not been made, and that foreigner is in the country during the consideration of the application. Here I come to the most important documents on the legal protection of migrants. On the international level, the main document that gives legal protection to these groups is surely the Universal Declaration of Human Rights from 1948. On the EU level, there's Convention on Human Rights and Fundamental Freedoms from Council of Europe from 1950, that in Article 2 and Protocol number 4 regulates the freedom of movement that the Convention guarantees to everyone who is legally present on the territory of the state. This freedom consists of three different rights, namely the freedom of movement and freedom to choose one's residence on the territory of the contracting state, as well as the freedom to leave any contracting state, which includes the freedom to leave one's own country. I have to mention Maastricht Treaty document from 1992 that changed the meaning of the free movement of persons when introduced the concept of citizenship of the European Union, which is automatically granted to every citizen of a member state. Of course, when speaking about human rights and migrants, public and professional institutions, legal institutions, should be driven by the sub lege libertas principle, which says that human rights are recognized for all migrants, regardless of their legal status. Some of the most important legal documents for the protection of refugees and other migrant groups are the Universal Declaration of Human Rights, which I've mentioned before, especially the Article 13 and 14. The UN Convention relating to the status of refugees and its protocol, which are central documents of the international legal protection of refugees. There's International Convention on the Protection of the Rights of All Migrant Workers and Members of their Family, which in the last couple of years in Croatia arose, and it's very, very popular, I would say, since we have many migrant workers nowadays, which I will speak maybe later in the Croatian part of the study. This International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families actually protects the rights of economic migrants, firstly. So this is the first document that defines migrant workers and their needs, as well as the needs of their families. There's also another document, which is Geneva Convention and amended by the New York Protocol. In the EU, these documents were bases for the development of the common policy of the EU on the status of refugees. We have also a Dublin regulation from 2013, which regulates the issue of responsibility for processing asylum applications. Under the current regulation, responsibility for an asylum seeker lies with the first member state they enter. We have another tool for protection of the migrants, which is called Common European Asylum System. This system aims to harmonize the definition of a refugee and the procedures and rights that must be respected when examining asylum applications, as well as the conditions for receiving asylum seekers, for example, accommodation, access to healthcare, and labor market. So, on the EU level, European Court of Human Rights in Strasbourg is the only body that decides in human rights cases and interprets and enforces the European Convention on Human Rights. I've also chosen several cases of the court, but I will just pick one for the sake of this presentation time. That case is Samos versus Bulgaria from 2012, where the court considered the justification of restrictive measures imposed on the applicant by the authorities of Bulgaria after he was deported from the United States of America for violating the immigration law. More precisely, in the aforementioned case, the authorities of Bulgaria issued a 3-year travel ban to the applicant, their citizen, after notification by the US Embassy, and confiscated the passport with a ban on judicial review of that decision. In this case, the European Court established violation of applicants' right from Article 2 of Protocol number 4 of the Convention, because the court judged that such interference with the applicant's right was not necessary in a democratic society. So, if you are interested in the European Court of Human Rights case law, I invite you to visit their official web page of the court and HUDOC site. Now I come to migration policies in the EU. There's something called EU immigration policy. And that's the public policy that has been developing within the institution of the European Union since the 1970s. And that encompasses issues of entry and integration of immigrants into the societies of receiving state, both nationals of member states and third country nationals. I believe we all remember the 2015 migration crisis, which resulted in several important things. First of all, it resulted in the Blue Card Directive, which lays down the conditions of entry and residence and the rights of highly qualified third country nationals and their families. And then we have Dublin regulation, which regulates the issue of responsibility for processing asylum applications for what I have mentioned before, right? We have the 2016 EU-Turkey deal, where Turkey accepted to stop the flow of irregular migration via Turkey to Europe in exchange for financial support. Also, we have Frontex, which is the European Border Protection Agency. And the most recent, from the last year, we have Pact on Migration and Asylum. And this, the fundamental issue of the reform by this pact is the search of the subject of responsibility for migrants and asylum seekers when they arrive, and whether other EU countries should be obliged to provide assistance. We also have integration programs such as language education, vocational training and employment support, etc. And now I come to Croatia. In history, Croatian migrations and Croatian refugeehood were very various. Unfortunately, Croatia has a rich experience in migrations of all kinds, in emigration, immigration, asylum seekers, displaced persons, everything. In the far history, Croatians mostly emigrated after World War I, World War II to Argentina, Australia, Canada, USA, and Germany. But after the Homeland War in the 1990s, Croatia was one of the main countries that had so many immigrants, especially from Bosnia, that had immigrants, Croatian and refugees who flew from Croatia to other Western European countries mostly. We have developed several acts on aliens protection. We have Act on International and Temporary Protection from 2023, which regulates the possibility of obtaining protection for persons who seek it in our country. We have Aliens Act from 2023, which regulates entry, movement, and stay of non-EU citizens in Croatia. We also have State Board Surveillance Act, which Croatia implemented to align its national legislation with the Schengen acquis and facilitate full Schengen area membership on January 1st of 2023. Another important office for protection of national minorities and migrants in Croatia is the Office for Human Rights and the Rights of National Minorities of the Government of the Republic of Croatia. That office coordinates the work of all ministries, non-governmental organizations, and other bodies participating in the process of inclusion in society of third country nationals who have been granted international protection. Is actively and of course is actively involved in the process of strengthening the integration capacities of the Republic of Croatia. We also have the regulation on the status of displaced persons and refugees from 1992, which defines the obligation of the Republic of Croatia towards displaced persons and refugees. As for the challenges and Croatian response to migration crisis, especially the last one from the 2015, Croatia did make some positive moves, I would say, to solve the crisis. For example, it took care of more than 1 million refugees and displaced persons since the Homeland War in the 90s to this date. It invested 38 billion Croatian kuna at a time in return programs over the past 18 years. But there is room or space to do more, much more. Managing refugee flows through Croatia, I would say that Croatia is actually, it was until several years ago, mainly a transit country. So for example, by January 2016 alone, around 600,000 refugees had crossed the territory of the Republic of Croatia towards Western countries. But nowadays, Croatia is seen as a good place for migrant workers. For example, we have a great number of foreign workers, Asian workers in Croatia, from Nepal, Philippines, India, and they are not just migrants. The Croatia is not just transit country for them, it's their final destination. Those people work in Croatia, they are socialized in Croatian society. One important thing I have to mention about this migration crisis, not just in Croatia, but everywhere. one, I don't know how to say it, one actor, one role, important role in public are the media. Media is an important tool in shaping the public debate on migration crisis. We had from 2015, we had newspaper articles, we had TV interviews, TV shows, etc., which went from tolerance and solidarity to now fear and disapproval of migration. The media have to be, firstly, well informed. They have to have knowledge of aforementioned terminology. Not all migrants are immigrants, as they like to say. They have to create a real and positive public opinion on migrants. And that's very important. I would like to add, for the end of my presentation, one last sentence that I've put here, and that is that belief in humanity is our only hope in a brighter future. Yes, so we cannot lose that hope in a brighter future at any cost ever. For we are humans. We are humans. We have to be humane. We can do that even starting now, by simply being kind to one another. I want you to take care, and I thank you for your attention, dear colleagues.